A federal judge has just told the Department of Justice something it clearly did not want to hear. Release the remaining Epstein files or come into open court and explain, under scrutiny, exactly why you won't. This isn't a leak, it isn't a rumor, and it isn't a political talking point. It's an actual ruling from an actual federal courtroom with a real deadline attached to it. Over the next several minutes, I want to walk through exactly what this order says, how we got here, what the Department of Justice is arguing on the other side, and what's genuinely still unknown, because there's a lot of noise around this case, and very little of it is coming from the ruling itself. The ruling came from U.S. District Judge Emmett Sullivan, sitting in Washington, D.C. He granted a preliminary injunction in a lawsuit filed by journalist and legal analyst Katie Phang against Acting Attorney General Todd Blanche. Sullivan's core finding is that the Department of Justice likely violated the Epstein Files Transparency Act, a law that has genuinely bipartisan roots. It was pushed through Congress by an unusual pairing, Kentucky Republican Thomas Massie and California Democrat Ro Khanna. And it was signed into law by President Trump last fall, after he had initially pressed lawmakers to kill it. That detail matters because it means the law at the center of this dispute isn't some partisan instrument being weaponized against the administration. It's a law the administration itself ultimately signed, that Congress passed with broad support, and that the courts are now being asked to actually enforce. The order gives the Department of Justice until July 2nd to do one of two things: either strip the redactions from a specific set of documents and release them, or have Todd Blanche personally appear in court and explain on the record why the department cannot comply. That second option matters more than it might sound. A show cause hearing isn't a formality. It's a mechanism courts use specifically when they suspect an agency has been slow walking a legal obligation. And it puts the department's actual legal reasoning under direct judicial examination, rather than letting it sit behind press statements. So what documents are actually at stake here? Two categories matter most. The first is a set of email exchanges involving Jeffrey Epstein that reference disturbing material, including references to a so-called torture video and communications touching on sexual activity involving underage girls. In these documents, the identities of the senders and recipients are currently blacked out. The court's order would require those identities to be revealed, unless the department can justify keeping them hidden. The second category is FBI interview notes connected to a decades-old allegation. A woman has claimed that back in the 1980s, when she was roughly 13 years old, Epstein introduced her to Donald Trump and that an assault occurred. I want to be very precise about this because precision is really the entire point of covering a story like this responsibly. This allegation is uncorroborated. Trump has denied it. He has not been charged with any crime connected to it. Now, why did the judge side with disclosure here, rather than accepting the department's objections? The DOJ's primary defense was procedural. They argued that Katie Phang should have pursued these documents through a standard Freedom of Information Act request, instead of suing the department directly. Judge Sullivan rejected that argument. His reasoning, according to the order, is that Phang had already been denied comparable FOIA requests related to these same files, and that the Epstein Files Transparency Act itself was written specifically to mandate a broader, less redacted release than a typical FOIA process would produce. In other words, Congress built this law because the normal disclosure pathway wasn't working. And the judge found that using the normal pathway as a defense against the new law didn't hold up. There's another detail in the ruling that's worth sitting with because it's arguably the most consequential line in the whole order. Sullivan wrote that Blanche himself effectively conceded that the department is already in violation of the act. That's not the judge's characterization. That's what the government's own filings acknowledged. On top of that, the department missed its own 1 o'clock deadline earlier in the week to respond to Phang's filings. And when it asked the court to pause the order while it pursues an appeal, Sullivan denied that request outright, calling the department's arguments unpersuasive. Taken together, You have an admission of noncompliance, a missed deadline, and a denied request for delay. That combination is why legal observers describe this ruling as unusually pointed for a discovery-related order. There's another detail in the ruling that's worth sitting with because it's arguably the most consequential line in the whole order. It's worth giving real weight to the other side of this because the story isn't as one-sided as it might look on the surface. The Department of Justice has announced it intends to appeal, and there is a legitimate, non-trivial policy interest sitting underneath all of this: victim privacy. Redacting the names and identifying details of abuse victims and of individuals only tangentially connected to a criminal investigation is a standard and defensible practice in document releases like this one. Reasonable people, including reasonable judges, can disagree about exactly where that privacy line should sit in a case this sensitive and this high profile. So the DOJ's underlying concern isn't frivolous. What actually undercuts the department's credibility here isn't the privacy argument in principle, it's the pattern of conduct around it. Missed deadlines, skipped filings, and public responses that criticized the judge's motives rather than substantively engaging with the legal reasoning in the order. That pattern is what shifted this from an ordinary disagreement about redaction standards into a ruling that treats the department's conduct as bad faith. Let's talk about what happens next, because July 2nd is the date that actually matters here, not any speculative timeline beyond it. If the Department of Justice complies, the public will see less redacted versions of these specific documents, the emails referencing that disturbing material with senders and recipients unmasked, and the FBI interview notes tied to the historical allegation. If the department doesn't comply, Blanche has to appear in person and justify the refusal directly to the court, a proceeding that would put the government's legal position under far more direct pressure than a written filing would. An appeal to a higher court could still delay any of this if that court grants a stay while the appeal is pending. But it's worth noting that Sullivan's refusal to pause his own order at the district level is a signal, intentional or not, that he doesn't see a compelling reason for further delay. And appellate courts don't intervene in discovery-related disputes like this one unless there's a genuinely extraordinary circumstance to justify it. Zooming out a bit, this case doesn't exist in isolation. It's part of a broader pattern this year of federal courts pushing back against executive branch resistance to disclosure obligations. In a separate and unrelated case, a different federal judge recently ordered the Department of Justice to hand over a different set of recordings to an outside organization after the department resisted that request too and lost. So what we're watching here isn't an isolated confrontation between one journalist and one federal agency. It's part of a wider tension this year between courts insisting that transparency laws actually mean what they say, and an executive branch that has, in multiple contexts, tried to slow walk or narrow those obligations. The larger question that this case is really testing is a structural one. When Congress passes a transparency law with a specific deadline built into it, and the executive branch simply misses that deadline, what actually forces compliance? The answer emerging from this specific case is that it takes a federal judge willing to deny a stay, set a hard date, and threaten a show cause hearing. That's a meaningful answer because it shows the law has teeth beyond just existing on paper. Now, let's be honest about what we still don't know, because a responsible breakdown of this case has to be as clear about its limits as it is about its facts. The identity of the woman who made the historical allegation against Trump has not been publicly disclosed, and there's no indication that this ruling changes that. The full contents of the referenced emails, beyond the specific quoted fragments that have already surfaced in court filings, are not yet public and won't be until either the department complies or a show cause hearing produces more detail. And critically, whether the Department of Justice actually complies by July 2nd, or instead chooses to escalate toward a show cause hearing and a further appeal, is still an open question as of right now. Anyone telling you with confidence what's going to happen on that date is speculating, not reporting. So here's where things actually stand. A federal judge in Washington has ordered the Department of Justice to release additional Epstein-related documents, or explain under oath in open court why it can't by July 2nd. The order follows the department's own apparent acknowledgement that it hasn't been complying with a transparency law the president himself signed. The documents at stake include emails referencing disturbing material connected to Epstein, and FBI interview notes tied to an uncorroborated, decades-old allegation against Trump that he denies and has not been charged over. The department is expected to appeal. And whatever happens on July 2nd, whether it's compliance, a show cause hearing, or an emergency stay from a higher court, it will tell us a lot more about how much force this transparency law actually carries against an executive branch that has, so far, been slow to follow it. So here's where things actually stand. A federal judge in Washington has ordered the Department of Justice to release additional Epstein-related documents, or explain under oath in open court why it can't by July 2nd. The order follows the department's own apparent acknowledgement that it hasn't been complying with a transparency law the president himself signed. The documents at stake include emails referencing disturbing material connected to Epstein, and FBI interview notes tied to an uncorroborated, decades-old allegation against Trump that he denies and has not been charged over. The department is expected to appeal. And whatever happens on July 2nd, whether it's compliance, a show cause hearing, or an emergency stay from a higher court, it will tell us a lot more about how much force this transparency law actually carries against an executive branch that has, so far, been slow to follow it. That's the story as it actually stands, built directly off the court filings and the reporting that's confirmed them, not off speculation. If the department complies on July 2nd, or if this moves to a show cause hearing instead, that's the next thing worth covering in detail, once there's something real on the record to report.